What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. Thank you for subscribing and watching the legal submissions throughout 2022. We wish you Merry Christmas, Happy Holidays, Happy Boxing Day, Happy Kwanzaa, Happy Hanukkah, and Happy New Year. We hope that 2022 has been good to you, and we wish you all the success in 2023. And before we leave 2022, I think it's great to give you guys an update on what everybody wants to know about the UFC Antitrust lawsuit. Now, I wrote on MMA Payout, which you should probably look up daily, about what was going on with the UFC Antitrust lawsuit. As we know, it's been pretty dormant for the last year or two since Judge Boulware indicated that he was going to grant class certification to a portion of the plaintiff's lawsuit. That meaning that the class cert would allow for fighters to be part of the class to sue the UFC related to anti-competitive issues related to fighter pay and other legal issues. The one thing that he indicated he would not pursue in class certification is the intellectual property rights of individual fighters. But it's a big issue, of course, because if class certification is denied, then fighters would essentially have to file their own lawsuits against the UFC, which could be burdensome and, of course, costly. If the class cert is granted by Judge Boulware, which he has stated in open court that he would grant, then the lawsuit would be able to go forward with the lawyers that are representing the plaintiffs currently. Now, there are other details going on. There's another piggyback lawsuit involving C.B. Dalloway and Cajun Johnson, where they have filed similar claims against the UFC. And this past year, the UFC filed a motion to dismiss, and the court, which is in Judge Boulware's court, denied that motion to dismiss, similar to how it denied the UFC's motion to dismiss in the initial Kung Lee complaint. Now, what's been going on? It seemed as though we hadn't heard from anything, any party or any inkling of a order from Judge Boulware this past year, and it was related to the fact that he was waiting on a Ninth Circuit Court of Appeal to this U.S. Supreme Court. The case Olean Wholesale Grocery Co-op versus Bumblebee Foods. Now, that lawsuit, how it relates to the UFC lawsuit, is based on Rule 23 of the Federal Rules of Civil Procedure related to class certification status and how that is granted. One of the parties in that Olean Wholesale Grocery Co-op case, we'll just call it the tuna case for right now, one of the parties, they had filed a writ certiorari to the U.S. Supreme Court requesting that the U.S. Supreme Court determine how class certification is granted. In that particular case, there was a dispute as to how the court determined who is an aggrieved party, an injured party, for class certification participation. Now, class certification requires 4 elements. The essential issue related to that is, does an injured party in that class need to be actually injured? Now, there was a lot of back and forth, and in fact, at the U.S. Supreme Court level, there were briefs filed by interested third parties on both sides of the ledger regarding class certification status. Now, why I'm telling you this is because it doesn't the holdup doesn't necessarily have to do with the merits of the UFC case, but it has to deal with how the rule applies to class certification status. Now, in the tuna case, it was determined that plaintiff's evidence proved that a common question is capable of class-wide resolution and that there is no per se rule preventing certification of a class that includes more than a de minimis number of uninjured members, meaning de minimis meaning a small amount. Whereas the opposing argument to this rule would be that there must be proof in plaintiff's evidence that all participants in a class prove that they are injured. The notable word in the Ninth Circuit Court of Appeals opinion is whether they were capable versus where they were actually injured. And that's central to what is being argued at this particular point. Now, central to the inquiry as it relates to the UFC antitrust lawsuit is the fact that the plaintiff's expert need not have to prove that all of the class of plaintiffs have been injured. Now, as you recall, there was a battle of experts in the plaintiff's case in determining the amount injured by plaintiffs from the UFC, how much the plaintiffs claimed that they were injured, and they had an economist argue that a lot regarding the UFC plaintiffs and their amount of injuries, and it was disputed by the UFC as to how plaintiffs came about to their conclusion. So while there may be a nominal number of uninjured class members, the argument by defendants in the tuna case and by the UFC is that more than a de minimis number of uninjured class members are part of the class action litigation. So we're not talking about just one. So the UFC and the defendants in the tuna case aren't talking about just one or two people out of a 500 person class. They believe that 10% of the 500 might be uninjured in the particular class. Now, obviously 10% doesn't sound a lot, but 10% out of 500 is what would be 50 people, and if you are the defendants, you would be disputing the class action certification if 50 people are allowed to recover on an amount that is that they actually could not prove if it was an individual case. So there's the rub. Also, the fact that there's a thing called standing, and standing in court occurs when you have an alleged injury. Now, if it's proven that you don't have an injury, then you don't have standing, and that would be one of the arguments by the UFC regarding these types of class certifications, where if you had an individual case where it's just one individual claiming the UFC about antitrust violations, then you have the issue of whether the actual claimed injury happened. In this class certification scenario, they take the bulk of the participants, and if they are capable of proving injury, then the class certification occurs. So what's going to happen in 2023? Well, the hope is that since the U.S. Supreme Court denied the certification, denied the appeal by the tuna defendants in the tuna case, that the UFC can now, that Judge Bulwark can now go forward with his opinion without inhibition about being overturned later on by the U.S. Supreme Court. What we would hope is that 2023, the first quarter of it, will see a class certification decision. Why? Well, because the UFC is going to appeal. That has been identified by the UFC already, regardless of how it turns out. They just need the opinion to dispute the conclusion by Judge Boulware regarding class certification. And that will lead to more waiting as far as as far as a conclusion for the UFC. Now, we've seen a little bit of movement as far as how contracts work. John Nash has outlined and highlighted the fact that there are arbitration agreements now. We've already talked about, like in the Francis Ngannou case, that there's hard stop sunset provisions preventing contracts to go past 5 years. We've seen that type of movement. Now, that doesn't mean that this makes the case go away unless the plaintiffs want to settle. But from what it seems like, we've dug in 8 years. I mean, we're not going to stop right now. So 2023, we'll be looking for more movement in the UFC Antitrust lawsuit, and we will be reporting on it as well. This is Jason Cruz with the Legal Submission. Happy New Year, everybody. Take it easy.